Order 36, they had elected by this particular conduct to adduce evidence in court, and therefore it was no longer open to them to tell the court that they were not going to give evidence. Of course, on Monday you heard the superior compelling arguments by Mr. Chikata, and of course you heard the wishy-washy, insipid arguments by the respondents. Nevertheless, the courts have ruled in favor of the respondents, saying that they do not agree with us, that even though this is the EC, a constitutional body, the same principles that are applicable to ordinary people should be applicable to the Electoral Commission, and therefore they were upholding their request not to mount the witness box. Subsequently, also heard Mr. Chikata. He said, well, if that is the decision of the court, then he's going to apply. In fact, he's in the process of filing an application for us to reopen our case and to subpoena the chairperson of the Electoral Commission. And so that is the status now. So now, for us, those are important. There are important lessons to be learned from this. Now we have an EC who, when a request for information was served on them in the past, they refused to respond. We have an EC who was requested to answer interrogatories. They refused to respond. We have an EC that was served with an application or a notice to admit facts. They refused. We have an EC that was asked to produce documents relating to the election. They also refused that. That's the kind of EC we are dealing with. I mean, where are the principles of accountability? When is this EC going to be accountable? Any questions?
Something about the
Yes, ma'am.
Counsel for Petitioner also announced that he will also file an application for review of the decision of the court. So that's 2 applications he'll be filing.
I'm sorry, review of the decision we had today.
Today's decision.
Okay.
He will apply for a review of that decision.
Okay, so maybe that even gives me the opportunity to ask this question. You have described as superior the argument made by Mr. Chikata against the application, yes, and as wishy-washy,
yes,
the argument made by lawyers for the respondents.
Yes.
How would you, in that position, describe the ruling that we have from the court today?
The ruling is the decision of the Supreme Court of Ghana. We have nothing to do but to accept it. We disagree with the decision, and so we are going to file an application for review.
Madam, now that the court has set the 13th for all parties to submit their addresses, now that the court has set the 13th for all parties, 15th for all parties
18th. Okay.
You file by 17th and your addresses, and the court comes back on the 18th. We know, as you said, you made an application or filing, you are going to file an application for a review, file another application for your case to be reopened. When you write your addresses and it's brought before the court, what becomes of these 2 applications, especially the one for you to reopen your case? Because then by the time your addresses would already be provided to the court. And what's next is that the court gives directions or a date for ruling.
Well, you heard his lordship. He said that nobody can stop us from filing an application. When an application is filed by a party, the court will deal with that application. And so we expect that the Supreme Court will take into consideration all these issues when dealing with the application.
Thank you very much, Madam. The Supreme Court was very clear in its ruling. It said that
I can't hear you.
I'm saying that the Supreme Court was very clear in its ruling. It said that a petitioner in an election petition case stands on its own strength, and not the respondent's witness. Is that what you sought to do?
I didn't hear the last
I'm asking if that's what you sought to do. I mean, using the respondent witness to make your case.
Definitely not. We have the strength of our case, but as we have stated over and over again, the EC is accountable to us. She has to account for how did those errors arise. When did she discover those errors? What was the process of correcting the errors? We've seen for some regions there are different summary sheets, different collation sheets. How did that come about? Who's going to answer this? Apart from that, remember that the petitioner is not the returning officer. The petitioner does not declare results. It is the EC or the chairperson that declares results in presidential elections. Does that answer you?
Well, my question is a follow-up to my brother's question. In giving their responses as to why the first and second respondents will not let their witnesses come to the box, the reason they gave was that the petitioner had not made a case strong enough to warrant them presenting any witnesses.
That's not what the Supreme Court. I didn't hear the Supreme Court say that.
Well, I would like you to give me your understanding of but that's how I understood it.
I never heard them. I never heard them say that.
That was what the lawyers, the lead counsels for the respondents, first and second respondents, one of the reasons they gave was that the petitioner had not made a case strong enough to warrant them presenting witnesses in the box. If that's not the case, I would like a response from you as to what you understood.
As simple. If we disagree.
Well,
as simple as that.
Because then my question would have been...
You heard counsel for the petitioner on Monday. And we disagree with that position. That the evidence that has been given points simply to the fact that that declaration of 9th December is null and void. None of the two candidates got more than 50% of the valid votes. There's only one declaration, 9th December declaration.
So the petitioner...
There were purported corrections. Have you seen any gazette notification dated on any of the purported corrections, the dates of the purported corrections? There is only one, 9th December, and the CI 135 talks about a declaration of 9th December.
Okay, so then, Honorable, if the petitioner does not get the chairperson of the EC to respond, does that then make your case a dead case? Because you seem to be insisting that she must, by all means, respond to certain questions.
And we will insist. We'll cross that bridge. But I believe that the petitioner we are convinced the petitioner has made a case.
Well, so the question is, if you are very sure in your case, why then the insistence on the EC entering the dock? Why would you not just allow the court to rule on what evidence has been availed to it so far?
I can't hear you.
I was saying that if you believe in the petitioner's case, why then the insistence on getting the EC, the chair of the EC, to enter into the dock? Why not just allow the court to rule on what matters?
Why don't we allow...
I am asking why the insistence on getting the EC to enter into the dock to be cross-examined. If you are sure about the petitioner's case, why not just allow the court to rule on your case so far, since the respondents are withdrawing from?
That there are questions that we put to her that only she can answer. Nobody else can answer. Irrespective of what case we have put before the court, there are questions in relation to this case that she alone must answer.
All right. You keep saying that you are depending, or you're not depending on the witnesses of the respondent.
We are not what?
And that you have your own special case. Can you tell us the exact case you are standing on to deal with this petition?
Have you seen the reliefs have you read the reliefs?
Yes, I am saying that you just said that you are not basing, or you are not even expecting the witnesses to make a case.
I answered the question that there are specific questions that she has to answer. It's as simple as that.
Let's do some 5 minutes. Yo, anyone, I say, and your bar court as Citrano. As someone at the court and impa or say Ubua and say a year my major mensa or dinner home electoral commission. I was say Oba Adakanum Noba Abeina Nuana. Monim say Nano Juada Yama a lawyer for ina Kwam Ubia Kanasem Namuina Zmutie in Samoa a year lawyer Chachuchikata or dinner homa a year petitioner no. Or the two dwa ewo court. We chire no ye kani na bom na ye baaye no ne court e ka kire ne se one yen enya adwen se maame no ebeba abetena adakanum na ade a nwoma ne se nsem misedi wo ho a ye bia to dwa edi kan ye bisa ye no ono a asem odi beto court enum a wadi nsi atachire ose ye back cross examination obeyi ano ye samba ye inspection ye ko nkrata bim o si ye back cross examination obeyi ano na se ye du se brabetna de kanu mbisa wa o se memma menko adakanum nanso court enyabua se onu de onu wom ya adwe se maame no monko adakanum enti ama ye lawyer pani enso de ato court nanim se ne o kan no woni wo nya adwen enti ye besan edin krata ba wo menim asra se wo nsanhwa asem no biom ye no nso fiwa ye san abesre court no se esanse ni ye close ye case ana ye wie case ansana ma me no ka se on ma da kanim nti ye san be bie ye case no so na ya sapina no ye ka se sapina ya makota hye no se omra da kanum na nsem wo so yi na ese so no kwa ne returning officer o Ghana nsem so bi say no bi ntimi yi no kire ono je mensa no betime yi no enti e ba makota ahye no e di sapina apoa atoa no akwa hye no so omra da kanum no omra me nsem na no enti we ni nsem mienu a ye lawyer for the ato court enim se ye di omu maame no beba da kam adaka ne de ye gusu gina bebi egina se maame no so twa no okupa no awo se maame no oba be gina adaka num so nya boni bia na so onfa bibia nsie de a adaka ne de ye be gina na nso se omra emegina adaka num enti bebi egina ene nsem yenu a ye de atudwe anu di akira nsana MPP fonso aba MPP fonso so omo so omo ba no mbe omo be yi omo no mpo anu so omo ba na omo be ya se ne ye general call no ni ehwe nim se magmenu nso baba ba mi se magmenu etwetwe ne nanse but wuni ekosia ne se ye de nsem ye no to court nenim 2 applications ye de baba court nenim na nyame ya aduma ya se bie ye nsem no so ne afre ma me no na be gina de kanim medam wase.
Thank you.